Namaste. Welcome back to the week 2 of Conflict Management through Mediation course. So in the last sessions, we discuss on the differences of alternative dispute redressal mechanism with mediation. Like we discussed arbitration and mediation, difference between conciliation and mediation, negotiation and mediation, and in today's session we will be discussing on the last part of or the last type of alternative dispute redressal mechanism, that is Lok Adalat with mediation. So the very nomenclature, that is Lok Adalat, itself means like it is Loka means people and Adalat means court. So it is the people's court. So, with an intent to provide the speedy justice to the citizens, the Legal Service Authorities Act of 1987 was enacted with an intent to provide equal justice to all by providing the legal aid, and for the first time Honorable Justice P.N. Bhagwati introduced the legal aid scheme by means of Legal Aid Committee established in the year of 1971. So, for the establishment of this legal aid scheme, it has the constitutional backup by means of Article 39A, which provides or imposes a duty on a state to secure that the operations of the legal system are fair, and it promotes justice on the basis of equal opportunity and shall in particular. Even Article 14, Article 21 and Article 22 also obliges for the state to ensure that equality before law and a legal system which promotes justice on the basis of equal opportunity to all. The same has also been held by Honorable Supreme Court in case of Husainara Khatun vs. State of Bihar, wherein Supreme Court held that there can be no doubt that the speedy trial is an integral and essential part of fundamental right to life and liberty enshrined in Article 21. And Article 21 further, the Supreme Court held that right to free legal aid as a fundamental right which is embedded within Article 21 of the Indian Constitution. So with this, the Legal Service Authority Act of 1987 was enacted with an object to constitute legal service authorities to provide free and competent legal services to the weaker sections of the society, to ensure that the opportunity for securing justice are not denied to any citizens by the reason of economic or other disabilities, and to organize Lok Adalat to secure that the operations of the legal system promote justice on the basis of equal opportunity. See, when we look after the population of India, there are huge diversity of citizens are available, and even there is various types of discriminations, like there are a lot of weaker sections, there are a lot of persons with disabilities and who are not able to come to or seek justice through the court of law because of their unaffordability, because of their inefficiency, and even if at all a person who is illiterate, he may not come to the court and argue. Under that circumstances, he is required to hire an advocate, and because of the huge charges of an advocate, he won't be able to afford the price or the charges of an advocate also. So with that intent, so the government of India came up with this act to provide a free equal opportunity to such people by providing legal aid by means of hiring an advocate on behalf of the such weaker sections, and arguing and for providing the justice to such weaker sections or economically backward class people or other disabilities people. So, with respect to this act, as empowered under the act, the various authorities are being established at national level, state level, district level, and taluk level. At a national level, we have National Legal Service Authority. At a state level, we have State Legal Service Authority. At district, we have District Legal Service Authority, and at taluk level, we have Taluk Legal Service Committees. So these authorities are empowered to scrutinize the applications made for legal aid and to allow the legal aid schemes. Even these authorities are empowered to provide legal aid service clinics and to conduct various workshops, awareness programs at the national level, state level, district level, and taluk level. So, we are required to provide, like as per the act, so the government of India or the National Legal Service Authorities or the authorities that are established under the act are required to provide legal aid clinic for the weaker sections. So who all are the weaker sections? To elaborate that, the section 12 of the Legal Services Authorities Act defines the criteria for providing legal aid. So these are the class of persons to whom the legal aid will be granted by the legal service authorities. So, scheduled caste and scheduled tribes, the person who is a woman or a child, a victim of human trafficking or a beggar, a person with mental ill or disabled person, a person under the circumstances of undeserved want, a industrial workman, a person in custody including custody in protective, and a person having an annual income of less than 9,000 rupees or higher amount as may be prescribed by state government. In case if the cases are filed before the Supreme Court, then the annual income should be less than 12,000 rupees or the higher amount as may be prescribed by the central government. So this is the criteria for providing legal aid, and these are the set of people who are eligible to apply for legal aid. So under section 19 of the act, it empowers the state authority, the district authority, that is the state legal service authority, the district legal service authority, the Supreme Court Legal Service Committee, High Court Legal Service Committee, and the Taluk Legal Service Committee to organize the Lok Adalat. And it also sets out the constitution of such Lok Adalat, that is, a serving or a retired judicial officer will be the presiding officer along with a other person. So this is the constitution of the Lok Adalat. So though Lok Adalat, there are two types of Lok Adalat. One is permanent Lok Adalat and another is simple Lok Adalat. So what types of cases can be referred, or to whom how the cases should be referred to Lok Adalat, or what is the jurisdiction of Lok Adalat, that is discussed in section 20, wherein the cases can be referred to the Lok Adalat with the consent of both the parties. With the consent of both the parties, the cases can be referred to the Lok Adalat, the cases which are pending before the court. The cases which are pending before the court may be referred to the Lok Adalat with the consent of both the parties. If the case has been pending before the court, either of the party can make application for reference of such case to the Lok Adalat as well. And where the court is satisfied that the matter is an appropriate one to take the cognizance by the Lok Adalat, the court will refer such matter to the Lok Adalat. Even so, how the Lok Adalat will decide? The Lok Adalat will decide on the basis of compromise settlement, and it is abide by all the principles of justice, equity, fair play, and other legal principles as well. and in case if there is no compromise or if the case is not been settled with before the Lok Adalat, then the matter will again return back to the concerned court from where it is been received, and the court will further adjudicate that matter and dispose according to the law. So this is how the process of Lok Adalat take place. The award of Lok Adalat shall be deemed as a decree of the civil court, and every award made by the Lok Adalat shall be final and binding on all the parties. When we say that the Lok Adalat, award of Lok Adalat is final, then it is implicated that no appeal shall lie before any of the court from the award of Lok Adalat. That is, the award of Lok Adalat is final and no appeal can be filed before any court against the award of Lok Adalat. So, what are the powers of Lok Adalat? So, the Lok Adalat shall be deemed to be a judicial proceeding for the purpose of summoning of witness. It can also discover of documents. It can also request the reception of evidences, and it can also the requisite for public records. So the Lok Adalat has all the powers which the court has, as if it is deemed as a judicial proceedings before the court. So what types of cases are suitable for Lok Adalat? So basically, the motor vehicle accidents, damage cases, family disputes, unpaid loans, land related cases, some civil and criminal cases which are compoundable in nature, and the cases related to unpaid bills. So those cases can be referred to Lok Adalat. See, basically what happens is like the court will determine whether this case is suitable for Lok Adalat based on the facts and circumstances of each and every case and refer such cases to Lok Adalat. Jurisdiction of Lok Adalat, when we say that it is very clear as to the jurisdiction of Lok Adalat that so any case pending before the court can refer to the Lok Adalat. So that is any case which is pending before the court of law. If there is any matter that this case can be settled through the Lok Adalat, the court may refer with the consent of the parties to Lok Adalat. Even it has a jurisdiction to entertain in a matter wherein which is falling within the jurisdiction of and is not brought before any court of law for which the Lok Adalat is organized. That means a person can directly file a complaint before the Lok Adalat as well. So in such circumstances, once the Lok Adalat receives the file or suit, the Lok Adalat will compromise and settle even criminal cases as well, which are compoundable under the relevant laws. So basically, when we look after the provisions, the powers of Lok Adalat, we trace out lot of advantages of this Lok Adalat. So here the Lok Adalat, justice at no cost. The Lok Adalat provides justice at no cost is because whatever the court fee which we have paid, and if that such case is been referred to Lok Adalat and the Lok Adalat decides the matter and settles the matter, so the court fee will be refunded back to the person who filed that case. Even it is speedier in justice because Lok Adalat there is no process, there is no procedure at all which has been followed at Lok Adalat. Hence the justice mechanism is very speedy in nature and save from the lengthy court proceedings, because at a court when we file a complaint or when we file a suit before a court, there are it's a very huge lengthy process as to, first of all, once the case has been initiated, then the court will forward a summons or serve a notice to the opposite party. The opposite party has to come up, the opposite party has to submit a written statements. Once he receives the written statement, then there will be examination of the witnesses. After examination of the witnesses, there will be arguments from both sides. After hearing the arguments, then the court will pass a judgment. So this is how the lengthy proceeding, whereas the process of Lok Adalat is very simple, wherein both the parties come together, wherein the presiding officer and the other person who will be sitting before the Lok Adalat, that is the constitution of the Lok Adalat, will discuss the matter and settles and try to settle at that moment itself. Even the solving of the problems, so this Lok Adalat is in such a way that it is acting in such a way that, and it is very effective with respect to solving problems of backlog of cases. When we have already discussed the statistics about how much backlog which we have at the normal courts, that is at Supreme Court, High Court and other courts as well. There is a huge backlog, and so this is Lok Adalat is one mechanism which is reducing the backlog of the cases. And the recent National Lok Adalat, which was organized on 11th February 2023, it disposed of 2 crore 6 lakh cases across India. So this is the amount, this is a huge amount, like 2 crore 6 lakh cases have been disposed through Lok Adalat on a single day. So this type of effectiveness the Lok Adalat has. Even it also tries to maintain the cordial relationship between the parties, because it tried to settle out the matter amicably by compromising the dispute. So this is how it also maintains the relationship between the parties as well. So basically this is about the Lok Adalat. Unless and until we understand the very concept of Lok Adalat, we won't be able to understand the difference between the mediation and Lok Adalat, and that is why we dealt in the first half with respect of this session with respect to Lok Adalat. Now let us come to the specific aspect of differentiating mediation versus Lok Adalat, or analyzing the similarities and differences between mediation and Lok Adalat. Coming to the similarities between mediation and Lok Adalat, both mediation and Lok Adalat are voluntary in nature, because the consent of the parties is must. Unless and until the parties consent to this process, like both mediation as well as Lok Adalat, the court cannot refer to the mediation, neither to the Lok Adalat. Even it is a voluntary process, because in both the circumstances, that is in mediation as well as the Lok Adalat, the party may compromise, the party may not compromise, or the party may settle, may not settle. If the matter is not been settled, it will again refer back to the court, and the matter will be settled as per the law. So that is how the nature of voluntary process is, and both mediation as well as Lok Adalat are voluntary in nature. The consent of the parties is mandatory. In case of mediation, the third neutral party will be assisting, that is the mediator will be assisting for the parties to resolve the dispute, and the role of mediator is persuasive in nature. The role of mediator is voluntary in nature. Coming to the Lok Adalat, wherein the presiding officer is acting as a neutral third party, will be assisting the parties, but his role is persuasive in nature. So this is the difference between the similarities between mediation and Lok Adalat. Now coming to the differentiations, as I already told, like the mediator will be acting as a facilitative role, and the role of presiding officer of Lok Adalat is in persuasive in nature. Because persuasive in nature is because, like, he is discussing the parties. He is not only playing a role of facilitator, but he may also provide some options. He may also provide what is the law, or what law says. He will also require to take care of that as well while deciding the matter before the Lok Adalat. So basically mediation is a party-centered negotiation, whereas in Lok Adalat the scope of negotiation is very limited, because in mediation the role of a mediator is facilitative in nature, who provides a facility for both the parties to discuss among themselves, that is to negotiate among themselves and reach at a settlement. Whereas in Lok Adalat there won't be any negotiations, but the presiding officer will decide based on the facts and circumstances, and even he tries to compromise the settlement. So that is why there is no scope for negotiation at all in Lok Adalat. In mediation, it is a non-adjudicatory process, because process is very clear, like the process of mediation is non-adjudicated because there won't be any arguments, there won't be any adjudication, there won't be any there won't be any deciding any right of the parties, but whereas they are negotiating themselves and reaching out to the settlement. So that is why it is non-adjudicatory process, whereas in Lok Adalat it is also non-adjudicatory process, but under certain circumstances, like wherein case of article section 22b of the Legal Service Authorities Act empower the permanent Lok Adalat to decide the matter, to adjudicate the matter, and even it also requires the permanent Lok Adalat to hold the conciliation proceedings and decide the matter or resolve the dispute between the parties. So this is why Lok Adalat is a non-adjudicatory process, but under certain circumstances, it will act as an adjudicatory process and adopts adjudicatory process and also conciliate the matter and resolve the dispute. So in case of referral court, so here the court empowers, in case of mediation, the court under order 23 rule 3 of CPC empowers the court to pass an order if in case the terms of agreement are being settled through mediation. Like if it is a post-litigation case and the court has referred that matter to mediation, under that circumstances, the mediator, once the matter is been settled through mediation, the report of settlement agreement will be submitted back to the court, and court on the basis of that settlement agreement will pass the order in mediation. Whereas in case of Lok Adalat, the award of Lok Adalat is deemed to be a decree of civil court and is executable as per section 21 of the Legal Service Authorities Act of 1987. So the Lok Adalat award will be deemed as a decree of the court directly, wherein the Lok Adalat, the presiding officer did not require to submit back such order back to the court and then pass out the order, whereas directly the Lok Adalat, the presiding officer can pass the order which will be deemed as a decree of the civil court. Both, once the matter is been settled through mediation or through Lok Adalat, in both the cases it is not appealable. The focus in mediation is on the present and the future, whereas in case of Lok Adalat the focus is on the past and the present. Basically, why? Because in present and in case of mediation, we focus, like the parties focus on the present as well as on the future scenario to maintain the relationship between the parties. Because if in case, let's have an instance, like if in case there are two businessmen who are working for their own business relations, when the dispute is been arised, so they want to maintain the relations in the future as well, so as to carry the future business relationship. So in that circumstances, mediation will be a best suitable option for them, because in mediation both present as well as future will be focused, whereas in case of Lok Adalat only past and present aspects will be considered while deciding the matter. In mediation, mediation is a structured process, whereas in case of Lok Adalat, the process of Lok Adalat involves only discussion and persuasions. Because in mediation we have a structured process, like the parties introduce, then the mediator introduce with the opening statement, then the parties move on to some joint sessions or private sessions, discuss, negotiate themselves and reach out to the settlement. Whereas in case of Lok Adalat, there will be only discussions between before the presiding officers, wherein the parties are required to communicate or discuss with the presiding officer and not among the parties itself. So this is how, wherein the presiding officer will be having some persuasive control on both the parties. So this is the another difference. In mediation, parties are actively and directly involved. In case of Lok Adalat, the parties are not actively or directly involved among themselves, whereas they will be communicating to the presiding officer. In mediation, the confidentiality is the essence of mediation, whereas in Lok Adalat, confidentiality is not observed, because in case of mediation, whatever they have been discussed during the mediation process, so those all will be in confidential in nature and that cannot be produced before any court of law. Whereas in case of Lok Adalat is held in open courts. So that is why the confidentiality is not observed in Lok Adalat. With these differences, hope you all understood the difference between Lok Adalat and mediation, and how mediation is helpful for resolving the dispute is because when compared to Lok Adalat, mediation is very fruitful as there is lot of circumstances. It maintains cordial relationship between the parties. It has confidentiality in nature, and even the trust of the parties are more. And in mediation, the past and present and future aspects will be focused on, and that is why the mediation is one of the important concept in resolution of dispute. Thank you.